de-escalated or discontinued. Fair?
Yes.
And we're going to continue to listen in, and we will cut in if we find any significant testimony. But I want to bring in our panel so we can sort of distill what we've seen so far today. Kimberly Atkins, columnist with the Boston Globe and an NBC News contributor, as well as a former trial attorney. Brian Dunn is managing partner of the Cochran Law Firm and a civil rights trial attorney. And Jonathan Capehart, host of the Sunday Show with Jonathan Capehart, right here on MSNBC, and an opinion writer at the Washington Post. Brian, let me start with the fact that today we saw the first witnesses for the defense. They included a retired police officer, paramedic involved with the arrest of George Floyd. They brought up a prior arrest. Now we're also hearing a witness who is an expert telling us exactly the opposite on use of force that we heard from the prosecution witness. What did you hear today? Was there something that said to you that they're building a case for reasonable doubt?
The way that I would, and thank you so much, Chris, but it's a great question. The way that I would look at it is the defense is taking their shot. Whether it's effective or whether it's not is not what I would take away from that. They're doing what they can. I think that when you start off with a prior arrest like that, it's important for folks to know that it's not so much about the incident as it is about trying to make George Floyd look like a person that has a history of brushes with the law, that he's got a serious drug problem. All of these things are aimed at the overall goal of trying to dehumanize him so that when the jury goes back into that room, they're not going to look at his life in the same way that they would someone else when they're considering degrees of murder.
So when they talk about things like, was it appropriate? Should they have started to de-escalate? The idea, as you see it for the defense, is for them to look at this cumulatively and say, he deserved it.
Well, that's a great point, Chris. And I mean, when you start talking about all of these points together, what's happening is the defense is trying to make this into an antiseptic, sterilized situation where they're relying exclusively on this is the rule, this is the way that things are done, this is procedure. But the problem that they keep running into is that video and the fact that when you're trying to get someone to do something that seems to go against their common sense or against their obvious perception, you really are going to have a problem connecting with lay people on the jury.
The defense, Kimberly, brought back a prosecution witness that had trained police officers, and they wanted to talk about something that's called excited delirium. I want to play that for you.
At some point, the defendant is on top of him. Is that right?
I think he had his knee on him. I'm not sure if I would describe that as being on top of him. I see his knee in the vicinity of the upper back and neck area.
Is it on the top or the bottom of Mr. Floyd?
It's on his back. Top being top of the head, or?
You tell me, is it on the top, the bottom, the side? Where is his knee?
I see his knee on the upper spine and neck area.
Is the upper spine then on the top?
Okay, we can use top.
Okay, you would agree with me then?
Yes.
Obviously, Kimberly, that's more recent. That's a different sound than we were looking at. But it is an interesting piece of sound because it is coming down in this, for this witness, to words like, what do you mean by on top? And they went back and forth about top of his neck, knee, did he have his other knee on there? I wonder what you made of that whole exchange.
Yeah, so that part of it actually does relate to excited delirium because the defense is really pushing two theories. One, floating this idea that something other than Derek Chauvin caused George Floyd's death. And the other side is saying that the other theory is saying that the use of force was reasonable. And this excited delirium theory says that essentially that the use of force was reasonable because when you have someone who was on drugs, they could somehow become, we've heard several times the use of the term superhuman strength, that they may not feel pain. And so, therefore, the use of force was reasonable. This is difficult for me for a lot of reasons. One, excited delirium is not a condition that is recognized by the medical community. It is something that is really a defense attorney's dream in that they are thinking it up. And it also really plays into the long historic racist tropes about black men, that they are somehow unhuman, that they are superhuman, they possess this brute strength, that they don't feel pain, that they are inherently more dangerous than other Americans, and therefore the use of force against them is justified. I think that it is dangerous both legally and in terms of what it means for our society if it does result in reasonable doubt enough to have an acquittal here. It'll basically be a judicially sanctioned approval of that kind of racist trope.
A lot of us were waiting and watching, Jonathan, and I know you have been watching today because I've been following you on Twitter, but a lot of people are watching to see what kind of defense Derek Chauvin's lawyer would mount. What for you today told you about where he's going with this and the likelihood, as you see it, of planting that seed of reasonable doubt?
Well, Eric Nelson has been planting this seed through his cross-examination of the prosecution's witnesses. I mean, to Kimberly's point, Eric Nelson has been trying to weave this tale of George Floyd as this superhuman, drugged-out maniac who caused his own death. And so now that the defense gets to have its turn and present its witnesses, now Mr. Nelson is having the opportunity to put people on the stand who will buttress and who will back up his theory of the case. But he's moving rather quickly through witnesses. So I don't know how much longer he's going to be arguing this case. He has a terrible hand, and we've all seen the evidence. He even started out by telling the jury, use your common sense. And if you use your common sense, anybody watching what we have watched would use their common sense and say, Derek Chauvin, with his knee on George Floyd's neck, killed him. And yet, to sort of echo what my colleague Eugene Robinson is saying in his column today in the Washington Post, despite that case that the prosecution made and presented, and now that the defense is giving its side, there is a part of me that is afraid that common sense will not be a visitor in the jury box. And that even though what the defense is presenting, and even though it might be knocked back by the prosecution on cross-examination, that Eric Nelson doesn't have to convince 12 people. He has to convince one, and he has to convince only one person to say that Derek Chauvin is not guilty, or not go along with the other 11 who want to convict him. And so that is my worry, is that there could be one person in that jury pool who will not use common sense, and for whom the racist tropes that we've been listening to since this trial kicked off, and that are now supercharged on high octane now the defense is presenting its case, will side with Chauvin.
Jonathan Capehart, Kimberly Atkins, Brian Dunn, thanks to all of you. Much appreciated. Again, we're keeping our eye on the trial as it continues. But I want to go now to my colleague, Ayman Mohideen, who is in Guatemala City, Guatemala.